The Honorables, the presiding Chief Judge and Judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Thank you, Mr. Thorpe. Good morning and welcome to the North Carolina Court of Appeals. Our case for oral argument, the plaintiffs Bensons, the defendant Prevost, and the third party defendants, Mr. Burnham and the Smiths. Are all parties ready to proceed?
Yes, Your Honor.
Yes, Your Honor. Ollie Crouch.
Yes, sir.
Yes, Your Honor.
Hear from the appellant.
Thank you, Your Honor, and may it please the court, I'm Bob Edmonds with the Greensboro office of Fox Rothschild. I represent the plaintiff appellants in this case, the Bensons, and I would like to reserve 5 minutes for rebuttal.
Certainly.
The keys to this case are two. The first is the timing of the events that have brought us here, and the second is the documents that were recorded and filed in the Register of Deeds office. The parties to this case are neighbors, but each purchased their lot from different sellers at different times. The Prevosts, or the defendants, bought first. They purchased their lot and house, which is lot 2. And if you stand on the main road and look at the two houses, theirs is on the right. They bought that in August of 2015, and it was sold to them by the third-party defendants. When the Prevosts bought their house, their access to their home was subject to a driveway easement. And it's set out on the plats and it's plainly labeled as a driveway easement. You can see them in our brief on pages 7, that's a 2004 plat, and on page 9, a 2015 plat. The Prevosts also have a 3-car garage under their house and a parking pad in front of their garage doors, and they own that pad in fee simple and thus have plenty of parking. The photos that are included in the record show as many as 7 vehicles can park in their property without touching the easement at all. What the easement does is it allows the Prevost access to Island Drive, the main road in that part of Wrightsville Beach. And the aerial photograph that's on page 14 of our brief shows the layout. So when they purchased...
I have a question. The aerial photo on page 14 does not match the map. It looks to me that the Benson home has actually been built on part of what's been recorded in the map to me, because if you look at page 14, that map that you have, that little part, that one part that's by the back gate, according to the map, is supposed to be 14 feet long. And that part doesn't even look like, if that truck is only 6 feet wide, that doesn't even look 6 feet. I mean, it looks like that part of the easement should keep on going toward the Benson home. So I just wanted to ask you about that. How did that arise? Has there ever been any dispute about the fact that your clients perhaps built that side gate and all this other stuff on top of what was recorded in the 2015 map?
I don't believe so, Your Honor. What you see illustrated on page 14 was done by hand, and we weren't trying to exactly match the meets and bounds that are shown in the plats. That would be what was controlling. We were just trying to give the court some understanding of the relationship of where the driveway was, where the driveway easement is, where the two houses are.
Okay.
So I don't believe there's any question about, I hope that question hadn't arisen. But the Prevosts, when they bought their house, got the dominant easement, but that driveway easement actually lies on land belonging to the adjacent lot, number 1. And when the Prevosts bought their house, they also got a boat slip. They thought they were getting boat slip A, but they didn't. The deed the defendants signed explicitly stated that they would be receiving boat slip C. Now, I'm going to discuss the boat slip and the driveway easement in more detail in a moment, but the point I want to make here at the outset is that the problems that the Prevosts are having with the driveway easement and the boat slips were baked into their purchase when they signed their deeds. They now object to sharing the driveway easement with the Bensons who owned the property on which the easement lies. But the Prevost knew the driveway easement was there when they purchased. They claim that they intended to obtain boat slip A, but the deed unquestionably shows that they got boat slip C. Excuse me. And this timing is critical in that my clients, the Bensons, had no involvement whatsoever when the Prevost made their purchase. It wasn't until later that my clients, the Bensons, purchased their house and their property on Lot 1. They bought from a different seller. The seller for them was Island Drive WB, whereas the Prevost had bought from the third-party defendants.
Mr. Edmonds, would, at the time, just before your clients purchased and it was in the hands of this separate entity, would the Prevost still have been able to reform their original deed with the sellers, or was it already too late?
I don't believe it was too late at that point, Your Honor. As I'm going to, or planning to discuss later in my argument, the Connor Act protects one, comes into effect once there's a subsequent purchaser for value. Now, at the time the Prevost bought, if it was just between them and the person who sold it to them, they could have sorted it out because there was no intervening purchaser for value. But once the Bensons bought, and as we'll see, the declarations indicate that the boat slip they bought was appurtenant to their lot. In other words, that boat slip C is appurtenant to Lot 2, and boat slip 1 is appurtenant, boat slip A is appurtenant to Lot 1. Once the Bensons bought, then the Connor Act protects them. But I think up until that point, it probably could have been just resolved the way you suggest.
And that intermediate holder, the corporate entity, that was not a transfer from value from the third-party defendants to that entity, right? It's a related entity, and there's no showing of consideration with that purchase, right?
No, I think the point is I'm not sure about the nature of that particular transaction, but as long as there's not an intervening party for value, they could have sorted it out, I believe. I may be wrong. I'm not a property lawyer, but I am pretty sure that under the Connor Act, once the Prevost bought, the Connor Act kicked in to protect them. But the Bensons had nothing to do with any misunderstandings about the nature of the easement that the Prevost nurtured, and they had nothing to do with any mistakes in the title as to which house gets which boat slip. And yet, the Prevost used the boat slip A as their own, and they frequently tie up the easement so that the Bensons can't get to their own backyard through their own backyard gate. The Bensons brought a declaratory judgment act to have the various rights and responsibilities resolved by the trial court. The trial court found against them in almost every respect. It said the Bensons could walk on the driveway easement, which is their own property, but that's it. And we say that ruling was erroneous. The three issues I want to talk about with the court are the easement, the boat slip, and the trial court's order of attorney's fees.
Let's talk about the easement. If the easement was wide enough to park cars, but would also provide enough room for somebody to drive back and forth, would you say that they would have had the right to park in there? Because the easement doesn't say ingress and egress, it just says driveway easement. Hypothetically, if the driveway was wide enough to where you could park in one lane and drive in the other, would it give both sides the right to park in the driveway if they wanted to?
Well, our position is this is not a parking easement, it is a driveway easement. If it were a parking easement, then you're probably correct, Your Honor. But in this case, parking, if you look at the pictures that are in our documentary exhibit, pages 2 through 8 has a slew of pictures, you'll see there's often a vehicle parked just as you say, but it does not appear to allow room for both to get through.
I understand that. I'm just saying if an easement was, let's say, 30 feet wide, and if you had an easement that was recorded, it was 30 feet wide, and it said driveway easement, and that's all it said, people do park in driveways. I'm just asking, in that hypothetical, do you think that it would be permissible for the dominant state to park if they parked on one side, as long as they gave access, ingress, and egress, that the surveying state could still access the back gate and whatever if it was wider? Or are you just saying that driveway easement, no matter how wide it is, always means you can only use it for ingress and egress? It's a hypothetical, but I was just wondering what you thought about it.
Yeah, I understand, Your Honor. I'm hard pressed to say that could never be parking.
Well, then we might have an issue here. Then we have an issue here because the easement that was recorded is 30 feet wide. And if your depiction on the aerial photo is correct, it appears that the Bensons decided to build on top of part of the easement. Basically, can they do that? I mean, if the easement really was built 30 feet wide, which is what that map on page 7 of your brief or 9 of your brief shows, would that suggest that they could have parked in part of it and driven it as long as it left room for the Bensons to get by? But now the Bensons have just decided to build a house on top of it. I mean, is that an issue in this case or not? Because I can't really tell, where the easement is on your photo because I'm looking at the map. So,
Judge Dillon, I don't believe that's an issue in this case. It's never been raised before because the question has always involved parking by the Prevost in a way that effectively did block the servient.
Well, then isn't also the fact that the Bensons, I mean, I don't know if this is the case, but if the Bensons built their house on top of the easement, doesn't that block their asset? They did it to themselves by blocking the easement, by building the gates and things. I don't know. I'm just, and I can't really tell from the record where the lines are, but your picture does not look like it's 30 feet wide. It looks like a little 10-foot wide driveway.
Your Honor,
Okay, I'm just looking at the record.
You're raising questions that were not litigated, so I'm afraid I really.
Okay, that's fair. That's fine.
And Mr. Edmonds, before you continue real quick, I just want to ask you about some of the pictures in your doc exhibits. I'm looking at page 7 of your reply brief where you have 4 of those doc exhibits. The bottom 2 pictures indicate not just vehicles, but bicycles parked in that area in front of the gate, and then what looks like piled up lawn equipment in front of the gate. Is there any indication in the record of when those photographs were taken and how long those items remained there?
Well, those pictures were taken by the Bensons, Your Honor. I am not sure when they were taken, but what they depict is vehicles that are parked and unattended, blocking the easement.
I'm sorry if that wasn't clear. I was talking about the non-vehicular items, the bicycles, the yard equipment, the ladder in those pictures in their reply brief. Any indication of when those were or how long they remained there?
I don't believe that's in the record, Your Honor. At least I can't point to anything in the record. But you can see that even though they're not the motor vehicles, they are unattended and they are, in fact, in ways that at least obstruct access to the back gate.
And it appears, especially that one at the bottom right, that even if we were dealing with a pedestrian easement, that's blocking a pedestrian easement would keep anybody on a wheelchair or anything like that from being able to get through that gate with that lawn equipment there. Is that an accurate depiction of the lay of the land there?
That's our understanding, Your Honor. I'm sorry, I'm sort of fishing around to make sure I'm looking. I know the pictures you're talking about. I just want to be looking at them. But that gets to the Prevost, the Bensons' main concern. If they wanted to have yard work done in their backyard, you can't. With things parked the way they are, you can't get a yard service tractor back there. If they need maintenance on their air conditioning system, that would be through that back gate. Those things are blocked, and that's just inconsistent with the rights that a servient owner has. Excuse me, let me continue here. This court has said in the Torres Bend case, 2007 case, that the sole and obvious purpose of a driveway easement is to give access to a platted road. And that's what the driveway does, or the easement does here. We know that the Prevost have plenty of parking, that's shown in the photograph, on the land they own in fee simple. But nevertheless, and the driveway easement is there to make sure that everybody can get to Island Drive. But they've been using it as if they owned it in fee simple, leaving boats, cars, and other things parked in it for extended periods. And the Bensons have been, Prevost have been pretty open about it. In his deposition, Mr. Prevost said the driveway easement was just another part of a private driveway and that he could use the driveway without restrictions. Ms. Prevost said in her deposition, "My parking calculation was based on using my driveway, and it wasn't divvied out per easement. It was my driveway." No, it's not her driveway. It's an easement. It's a driveway easement. It's for the mutual use of the benefits in the Prevost. But the Prevost seem to want the whole thing. They want to use the easement for their convenience in any way they want. And in doing so, they often obstruct the Benson's access.
When was the Benson home and the back gate and the side gate? When was that built?
The house was built, Benson's closed in 2016, and I know they initially began the contracting process in 2015. So I don't know the exact date of completion, Your Honor, but it's 2015, 2016.
So the Bensons closed. They bought a house. They didn't buy just they didn't buy a lot. They bought a house.
Well, when they started, the house was under construction. When they closed, the house had been completed.
Okay.
That's
okay.
Well, I'm sorry. I'll return to the point that the Prevosts have been calling the what we say is the easement. They've been calling it my driveway. In contrast, the Benson's position is that neither can monopolize the easement. They understand it's for their mutual convenience, and the court pretty much agreed when it addressed a similar issue in the Hundley case. In Hundley, the owner of land held a servient easement, and the holder of a dominant easement put up a fence that prevented the owner of the property on which the easement lay from using it. And more to the point, in that case, the dominant easement holder had a exclusive easement. But even with that exclusive language, the Hundley court held that, and I'll quote, "Absent explicit language to the contrary, the owner of land subject to an easement," that would be the Bensons, "has the right to continue to use his land in any manner and for any purpose which is not inconsistent with the reasonable use and enjoyment of the easement." Here, the easement is a driveway easement. It's pretty much a self-defining term. It's not a parking easement. It gives access to Island Drive. Yet the pictures show that the Prevosts have used the easement pretty much as their private vehicle parking and storage area. They even park in the easement in such a way as to block that back gate when other parts of their own driveway are clear. You can see that in some of the dock exhibits photographs. So apparently perceiving themselves as the fee simple owners of the property on which the driveway easements lie, the Prevosts do everything on the property except pay the taxes, and they're willing to let the Bensons do that. And it's more than just an inconvenience. As we pointed out, any equipment that needs to go to the back area for boat slip maintenance or anything, that can be blocked. And nobody wants to take a lawn tractor through their house to get to their backyard. What I suggest to the court is the most practical way of looking at this easement is being similar to a loading zone. If you drive somebody to the airport, you can pull into the loading zone, you can put your car in park, you can get out, you can take the luggage out of the trunk, you can see your passenger to the curb, you can give them a kiss, and then you've got to leave. You can't leave the car there unattended, you can't leave it there indefinitely. But that's exactly what the Prevosts have been doing with this easement. Even so, the trial court said that the Bensons, the property owners, are allowed to walk in it. Nowhere does the trial court's order indicate any awareness of Hundley's holding that anyone in the Benson's position has a right to continue to use their land in any manner and any purpose which is not inconsistent with the reasonable use and enjoyment of the easement. Instead, under the order, the Prevosts can continue to do what they have been doing, and they can make the pedestrian quite illusory by parking as they've been doing. So it's our position that the court's order is inconsistent with the jurisprudence of this court. The correct result would have been summary judgment in the Benson's favor.
Mr. Edmonds, before
Yes,
you
sir.
transition, I want to look at page 4 of your reply brief. In the middle there, after the Hundley citation, you have a sentence that further acceptance of the Prevost argument would alter the meaning of countless driveway easements existing statewide. I don't see any record citation there. Well, I think that's a pretty accurate statement. Is there anything in the record you can point us to that would support that, or is that something we can take judicial notice of? What the language of other deeds and easements across the state may or may not be?
I think it would be a matter there is nothing in the record that, that wasn't explored through testimony or exhibit evidence that I'm aware of, Your Honor. But driveway easements are routine. I mean, if you do a Google search of driveway easements, you're going to find a lot of them. They're commercial uses and so forth, where you have access to apartment areas and so forth, or shopping areas. If this court issues an opinion in this case that's inconsistent with Hundley and Torres, then that will affect a whole lot of driveway easements. I just want the court to be, if it's going to do so, to do so advisedly. As the court, I'm keeping an eye on my time, Your Honor. The difference between the boat slips is that boat slip A has a boat lift and makes it somewhat more attractive. But when they bought, the Prevost thought that they were getting each house in the area has water access and has a boat slip, and the Prevost thought they were getting boat slip A, the better one, because it has the slip. But their deeds, which are the pertinent languages in our brief, specifically says, no, you're getting boat slip C. And that's consistent with the Island Drive Dock Association's previously recorded declarations. So that's what they got. And this language is critical. North Carolina is a pure race jurisdiction. The Connor Act and the cases applying it say that what is recorded in the Register of Deeds office is in control. And if one of the parties made a mistake, or if there was a misunderstanding, it doesn't void the transaction or put a cloud on the title. Those dealing in real property and titles can and do rely on the chain of title reflected in the recorded instruments. So after the Prevost closed, when the Bensons later purchased their lot, they were shown the documents for their purchase, and those documents showed that they were getting boat slip A. Well, they'd seen the Prevost were using boat slip A, and they thought they were going to get boat slip C, so they pointed out the discrepancy to the closing attorneys. And their attorneys reviewed the chain of title documents with both boat slips and confirmed to the Bensons the clear chain of title, that they were getting clear chain of title to boat slip A. We dealt with that in some of our reply brief to the third-party defendants, but you'll remember that Ms. Benson is a lawyer, and she testified that in her deposition that they were assured that there was not an error and that they would not have closed if there had been an error. So they recorded and they got boat slip A. And the issues of the driveway easement and the boat slip easement became entangled. The Bensons want the boat slip, the better boat slip. The Prevost want the better boat slip, and the Bensons want the Prevost to stop monopolizing. Mr. Benson, I would call the court's attention to the exchange on pages 213 to 215 of the documentary exhibits. Mr. Benson said the dock issue between Mr. Benson and Mr. Prevost. Mr. Benson said the dock issue will need to be resolved. Quite honestly, we don't want your dock, and we have no issue with just agreeing to amend the titles to match the intent and usage as it is today. Mr. Prevost, as I said, we have different understanding how the easement works that was shaped by the considerable discussions conversations with the sellers, D and Dan, in person as with the other diligence conducted by our evaluation and purchase of the house. Our understanding is that we have full use of our driveway. In other words,
Now, when the Bensons bought their property and they saw that the boat slips there was kind of a mess up there, did they make any representation to the seller who originally owned both of them that let's go ahead and close, we'll switch later? Did they say that they would switch later, or did they say that we'd work? I mean, is there any evidence that the Bensons said we'll switch it with the Prevosts later?
there's contested at that point.
Well, would that create some sort of parole trust, which North Carolina does recognize? If you make a promise, an oral promise that you're taking title, but it's for somebody else, is that evidence of parole trust that would then make summary judgment not appropriate in this case? I'm just asking the question if there's conflicting evidence on that point. Or I don't know if the Prevost made a claim for a resulting trust. All I remember is they're just saying that they wanted reformation based on a mistake.
Your Honor, I'm sorry, I get a little distracted here.
The parole trust is the question. Is there any evidence that there was a parole trust when the Bensons bought the property? They bought it understanding that they were going to transfer it to the Prevosts. That's
the Prevost claims. The Benson's deposition testimony is that there was no promises made. And that they were assured by the attorneys that there were no mistakes. So that could be a disputed issue, but I believe under the Connor Act, even if the Bensons knew there was a mistake, they would be protected because this is a pure race district. Your Honor, I'm sorry.
Mr. Evans, I see you noticed that your time is coming closer.
I would like to
you can answer this later, but I have a question real quick. Is any of that conversation about the parties and what's going on before closing and their discussions during all this competent, or is it just a part of settlement negotiations, which isn't admissible anyways? So maybe if you want to touch on that now or later, it's fine.
I don't think it's competent, Your Honor. Most of the discussion is between the lawyers who are trying to figure out what's going on. Our clients have been pretty straightforward and consistent in their position that they didn't promise anything. But I would like to save the remaining time.
Certainly, sir. Thank you.
Thank you very much.
We'll hear from the appellees. Mr. Shipman,
Thank you.
certainly.
May it please the court. As was the case in the trial court, the appellants largely ignore facts in this case that exist without material dispute and fail even on this appeal to show that there was any justiciable issue based upon those facts that exist without material dispute, only those that they imagined. No evidence was ever presented to the trial court that the intent of this driveway, which had existed in its configuration across Lot 1 since 2004, was ever intended for ingress and egress only, or no evidence presented that it was never intended by the creator of that easement that the defendants not be permitted to park in their driveway. A driveway that had again existed along the border into the boundary of Lot 1 since 2004, used by the house that had existed since 2004, quite frankly, existed prior to that. No evidence was ever presented to the trial court that the deed of easement, that the recorded 2 plats that showed this driveway easement was ever limited to ingress and egress.
Let me ask you a question. When your client bought the house, and I'm looking at the picture, the street view picture, I know the fencing was around the Prevost's house. Was any of that fencing in place that goes around the Benson's house and the back gate? Was that there or was it not?
No, sir.
You know,
It did not exist at the time that our clients, the Prevost, closed on the purchase of their house, but it was consistent with the marketing materials that are in the record that showed that there was going to be a privacy wall. So, as the evidence undisputed showed, that the Prevost would have a Charleston-style courtyard at the end of that driveway. It was only after construction started on lot 1 of the home that the plaintiffs eventually purchased, and this wall that was constructed, that a gate was ever installed, meaning you'll note that of the materials presented to the town of Wrightsville Beach, the marketing materials that were presented, there was never any indication that there was to be a gate in that wall at all. That wall was to be a privacy wall. The term autonomy was used.
well, let me ask you this. I mean, the map that's the 2015 map shows that the driveway easement was 30 feet wide. I mean, in the back, and it looks like in the picture it's a lot narrower. So nobody really makes an issue. Y'all don't make any issue to the fact that it looks like the Bensons actually built their privacy wall that runs along the side of their property. It appears it would encroach in whatever easement was filed in 2015. But am I wrong about that?
Certainly not according, Judge Dillon, to the map. And that is the point. Your point was, if the entire width of this driveway were 30 feet wide, would it be reasonable that the servient estate might be able to park in addition to the dominant estate? And if that were the case, the answer may be yes. But in this case, the evidence was the intent was to create a private driveway for lot 2, given that there was a separate private driveway created for the benefit of lot 1. Keep in mind, this driveway originally extended at its terminus into lot 1. They had to move that driveway so that they could build a house on lot 1. And again, all of that evidence is in the record. It exists without material dispute. No evidence was ever presented to the trial court to support the allegation.
What do you mean that? Well, hang on. What did you mean the easement was moved so they could build a house on lot 1? Because the easement's pretty much in the same place that it was in 2004. Just it actually extends more to lot 1 than it did before.
Well, they had, Your Honor, I don't have that page, but there, if you look at the 2004 recorded plat,
I see that.
and then the 2015 recorded plat, they shifted it slightly. They shifted the dimension slightly. The width, though, of what has been referred to in arguments as the quote sleeve, it didn't change. It did not become wider. It stayed roughly the width of a car. And so back to your
It's
point,
not the width of a car. If you look at the map, and I looked at the legend says that that line at the driveway is 35, it's like 40 feet wide, and to the top of the back gate, it's 15 feet wide, 14 feet wide. I mean, if you read the map. Now on the ground, it looks like it's only like, it's not that wide, but
well, that was my point, Judge Dillon. The paved portion, the part that is actually used to drive cars in off of Island Drive, is not the full width of this driveway easement. And the only issue here is whether or not it was intended when the third-party defendants created this driveway easement and recorded the plat in 2015, was a reasonable use of that driveway easement to park cars in the driveway. As Your Honor knows, when an easement is conveyed and there are no specific restrictions on the use of the easement, a reasonable use is implied. Uses that are not only reasonable, but convenient. And there was obviously never any evidence that was presented to the trial court that any of the uses being made of the driveway easement by the Prevost were inconsistent with the purposes for which it was created. As a matter of fact, the evidence that exists without material dispute is that all of the uses that they were making were uses that were consistent with the purposes behind the creation of the easement. Judge Dillon, Judge Murphy, you might have asked questions about bicycles, equipment that was located near the gate. Understand that nothing in this record supports the notion that any use of this driveway by the Prevost ever at any time interfered with the ability of the plaintiffs to gain access to their backyard when they wanted to.
Okay, let me ask you a question. So when the Prevost bought the house, the driveway was there and the house was there. Is that correct?
Yes, sir.
Okay, but there was nothing on lot 1. Is that correct?
No, sir. That's correct.
Okay, so the driveway easement, as it appears on the map, actually extended more into lot 1, at least, and then the Bensons came, or the previous owner, whoever, built a house and started building part of this and erected the gate that actually encroaches on the easement as filed.
Yes,
As I see it, I mean, and then they built this gate on the back. And okay, I want to make sure I understand. So that wall was not there that surrounds the Benson's house. And then they built it on land that appears to encroach on what was actually recorded. I mean, is that correct?
Yes, sir. The privacy wall was erected after the Prevost closed on their property and prior to the time that the plaintiffs closed on their property in June of 2016.
But the Prevost has never complained about the fact that this wall was built over on top of their easement.
The only complaint, if that's a proper characterization that was made, is that no one talked to the Prevost about the idea that there would be a gate in that wall and that therefore the plaintiffs could walk from their front yard to their backyard. But they haven't complained about that because that impeded their use, the Prevost's reasonable use.
And Mr. Shipman, let me ask you a question real quick before we move on from the deeds. I'm looking at record page 48, and in the property description portion, for boat slip C, it says together with boat slip C. For the driveway easement, it says together with and subject to a driveway easement shown. What is the importance of the addition of the word subject to there instead of just the together with? If the Bensons don't have a right to share in the free use of that easement.
The limitation that was presented by the third-party defendants, who again, different entities, but the individuals with the third-party defendant and the grantor to the plaintiffs are the same. The evidence that the intent behind it, the subject to, was to enable the enable the plaintiffs to access their backyard over pedestrian access over that easement from their front yard to their backyard. Even the plaintiffs admitted prior to their closing, which becomes important to look at what did they know and when did they know it. Keeping in mind that, as Justice Edmonds pointed out, Ms. Ribaldo is a lawyer, and she says the sole basis upon which she contends that nobody can park in this driveway easement is a dictionary definition. She admits no one ever told her that. If you look at page 30 of her deposition, she says, now, would you agree with me, either during the due diligence period or prior to closing, you never saw a document that says this driveway easement was limited to ingress and egress? And she said, no, because I relied on the dictionary definition of an easement. They knew the purposes for which those easements were created. They knew, based upon the conduct of the third-party defendant who created the deed of easement that outlined what the intent was behind it, which the plaintiffs threatened to sue the third-party defendants if they recorded that deed of easement. They knew from their own appraisal that they obtained on their property prior to closing that there were adverse site conditions on lot 1, namely the, quote, parking access easement noted for the adjoining property. They knew the content of the disclosure statement that they signed at closing, in which they made that disclosure that made clear that this driveway easement runs to the benefit of lot 2, not lot 1, that created rights superior to the rights of the Bensons into that property. They signed that disclosure.
But can you take that position? I'm looking at record page 65, paragraph 21 of your answer, your client's answers. It is admitted the driveway easement is for plaintiffs and defendants and their respective guests to use for vehicular and or pedestrian ingress and egress. This part of the answer wasn't ever amended, right? The only amendments were to add defenses.
Your Honor, if you look at paragraph 21 of the complaint, the allegation is that its purpose was limited to vehicular and pedestrian ingress and egress only. And we said, except as herein admitted, the remaining allegations are denied. But we never admitted that the only purpose for which this could be used was ingress and egress, a point that we made clear to the trial court. But it is. Go ahead.
But it is an admission that the trial court erred in by saying, at least under the admissions in your complaint or in your answer, that the plaintiffs were limited only to pedestrian use and not to vehicular use.
We denied it was limited, Your Honor. We admitted that it could be used for vehicular and pedestrian ingress and egress, but that's not the only purpose. And that's what they alleged. If you look at paragraph 21, they alleged that was the only use that could be made, and we denied that. So
I understand that, but I'm talking about the trial court's order then, though. So at a minimum, would you concede that part of the trial court's order is error? Limiting the plaintiffs to pedestrian use versus vehicular use?
well, it says is for plaintiffs and defendants and their respective guests to use for vehicular and pedestrian purposes. No, Judge, we do not believe any evidence was ever presented that the plaintiffs may make vehicular use of that. Now, there have been occasions, as the record shows, where the plaintiffs asked the defendants, asked permission, if those providing service to their house on lot 1 could drive into the end of that sleeve. And that's never been denied. So again, if a service vehicle, as long as it does not interfere with the Prevost use of their driveway, sure, that would be reasonable because it does not interfere, but they can't park there. They can't. They've got their own driveway. They can't, as they do in their own driveway, park in their own driveway. They can't park their vehicles in our driveway and then go to their house because they have their own driveway.
But how would the Bensons exercise their right to, say, have a service person come in, say your clients park their boat or leave their vehicle there and go out of town for 2 weeks? How would they access or exercise that right to back in a service vehicle or to pull something through that gate?
Well, first, again, there's no evidence in the record that any effort has been made by the plaintiffs to do that. That was denied. Next, that Prevost don't live there full time. It's a vacation home. They're only there, as the record shows, 25% of the time. When the question was asked about the bicycles, the garden equipment, there's no evidence that was ever left overnight or it was ever left for any prolonged period of time. That, again, ever prevented the plaintiffs from making reasonable use of whatever rights they wish to exercise in that driveway easement. Yet their complaint said that there was. They produced no evidence whatsoever that had ever happened, ever. The pictures speak for what the conditions were at the time, but there was no evidence whatsoever that any use that the plaintiffs desired to make of this driveway easement had ever been impeded, much less the intended uses.
But this lawsuit is not just about the actual impediments, about the legal rights. And under the order, I don't see anything that would prevent your client from leaving a boat parked there for 6 months when they're back at their other home.
Your Honor, we're dealing with the term temporary versus permanent. First, as we pointed out to the trial court, town ordinances from the town of Wrightsville Beach would prohibit what Your Honor just said, parking a boat there for 6 months and just leaving it. That can't happen. Okay.
But the town's free to amend its ordinances at any time, so that's not binding on the deeds.
Well, sure, but again, the issue is temporary. What is temporary? Overnight? Sure. Over a weekend? Sure. Permanently? 6 months? Leaving something, a vehicle parked in a driveway? No, that would be unreasonable. But again, no evidence, nor do I think this court should go this far in determining what is reasonable and unreasonable based on facts that don't exist in the record. And given that there are no facts that exist in the record that that kind of use, Judge Murphy, has ever been made by the Prevost of that driveway, it may be an issue to be resolved at some later period of time, but it is not an issue to be made now because, as a matter of law, given that there were no restrictions by the deed or by the plat, given that a easement is a contract, then the Prevosts are entitled to make reasonable use, consistent with the purposes for which it was created. The court, if the conveyance is not clear as to what those restrictions were, was entitled to receive and did receive extrinsic evidence as to the attendant circumstances surrounding the creation of the easement, the conduct of the parties to that easement immediately after its creation, and again, what uses were reasonable and convenient based upon the purposes for which this easement was created. Every bit of that evidence was completely uncontradicted. It was without material dispute.
I don't want to keep harping on this point, and I know you need to spend some of your time moving on to the other issues here, but I'm looking at record page 150, the trial court's order, paragraph 9, and it says parking, nothing about temporary. Is there something else in the order relating to a shorter term or temporary parking? Because those are two different things in my mind. Can you point me to anything in this order that would say that that parking is limited to a temporary basis?
Just a second here. No, but that gets back to my point, Your Honor, that a permanent, back to your point, parking a boat there for 6 months and not moving it, that would be unreasonable. There need not be any specific document that says what is reasonable and what is unreasonable, other than the fact that the plaintiff sought a declaratory judgment that parking was an unreasonable use. Again, with not any evidence in the record that any permanent type parking or any parking of anything had ever been engaged in by the Prevosts during the entire time that they had used their driveway. So I don't think, that it is incumbent upon this court to enunciate the types of uses that would be unreasonable, given that there's no evidence before the court or the trial court that such uses were undertaken by the Prevosts. All of the uses that the Prevosts have engaged in, according to the undisputed evidence, were entirely consistent with the purposes behind the creation of the easement. Certainly, Judge Murphy, the deed of easement created by the third-party defendants, conduct consistent with the use of the easement, uses the term temporary, whatever that means. But of course, that document wasn't recorded. But that is evidence, we contend, of what is a reasonable versus an unreasonable use of this driveway easement by the Prevost. Let me turn my attention, if we
real quick on that point, probably transition well into some of the other things you're going to say, but is there any cases that suggest that a rejected offer of settlement of issues should be used to determine the intent of parties in dispute?
Your Honor, it wasn't any offer of settlement at all. Ms. Rabondo asked if there were additional documents that set forth what the nature was of this easement. In response thereto, the third-party defendant had this deed of easement prepared, provided it. Our clients knew nothing about it until after this litigation started. They had never seen the document, had no role in its preparation. And when third-party defendants presented that to the plaintiffs, they threatened to file a lawsuit if the deed of easement was recorded. So it wasn't a settlement at all. It was a document that was intended to reflect the intent behind the creation of the easement, period. There was no controversy at that point. It was prior to closing. So there wasn't anything to resolve at that point other than the plaintiffs proceeding to close, which they did.
Well, there'd already been a little bit of a dispute about the gate being there, correct? When your clients thought it was just gonna be a privacy wall. So there was some dispute at issue.
If we were contending that that gate constituted an unreasonable use of the easement by the plaintiffs, sure. But we didn't contend that. We haven't contended that. We've never prevented them from gaining access from their front yard to the backyard through the use of that gate, even though we didn't know anything about it until after it was installed. That wasn't before the trial court.
Now, when your client bought the house, did they know where the Benson was going to build their privacy wall, or did they not know where it was going to go?
They didn't know, Judge Dillon, precisely. They knew it would largely provide a privacy between lot 1 and lot 2, largely frame the driveway, and then leave on the marketing materials and on actually the recorded plat. There is a area outside of the paved portion that the evidence indicated was in fact the path that was intended for the plaintiffs to use to access their backyard, that didn't require them to even walk on the paved portion. And that evidence was in the record, that there is an area that's not paved that can be used to access the backyard.
Yeah, I just wondered if the Prevost knew that they were going to build the wall on top of on top of the easement area. That was what I was wondering.
There's no evidence that they knew of that because of course they had no control over it.
Mr. Chairman, talking about that area, on the left side of the driveway easement, as we're looking at this picture that has the houses, or the house and the yellow driveway easement on it, who maintains or who's responsible for maintaining the landscaping between the wall and the driveway surface?
Judge Murphy, there's no evidence in the record about that, but said another way, there's no evidence in the record that the plaintiffs maintain that. Because again, that was not an issue, nor, as Justice Edmonds said, that they pay the taxes. There's no evidence in the record about what taxes that the plaintiffs pay on that portion of the property that is the driveway easement. Although they contended that there was a diminution in value of their property, the evidence was there was none. And in fact, the evidence was to the contrary, that their property had actually increased in value. Let me move to the boat slip. There is no question but that the Prevost executed a contract that provided that they would get the southernmost boat slip with the boat lift. There's no dispute that it was slip A. There's no dispute that the conveyance of this boat slip did not convey them slip A, conveyed them slip C. There is no case that's been cited by the plaintiffs where the Connor Act has ever been applied to a boat slip over public trust waters. I challenge them, if there is such a thing, to provide it, because there isn't. There's no evidence that's been presented to the trial court that this boat slip was permanently affixed to any real property so as to characterize it as a fixture.
But I think there's case law that says that the owner of riparian rights has the right to build piers and whatnot. And the owner that owned all these lots together owned the riparian rights and had the right to build docks out there. And then when they subdivided the lot, it appears to me, I think how would you answer this question? When they subdivided the lot, they filed something that gave the riparian rights to that access to that portion of the public trust waters to lot 2 and the other part to the other lot. I mean, it is a riparian right is an interest in land, which includes the right to access the water through a pier.
I agree, Dylan, but that does not make the pier real property. That does not make the boat slip real property. And the Connor Act only applies to real property. Next, the plaintiffs are not a bona fide purchaser for value. They knew all about the mistake. their lawyer made contact, and the evidence is undisputed, the day of closing in email communications, pointed out the mistake, indicated that after closing, that conveyances would be swapped. The question was asked, is that a parole trust? No, we contended to the trial court, that works in estoppel. You can't now come in here and say that you ever thought that you were the rightful owner of slip A, given that your contract, the plaintiff, mentioned nothing about a boat slip.
Okay, now I will say this. If I sell you my house and I don't record a deed, and then I turn around and sell my house to Judge McGee, and Judge McGee knows I deeded it to you, but she pays me money and beats you to the courthouse, I think she wins. But was there any evidence? So I don't know if I buy that part, but was there any evidence that the Bensons promised, yes, we will deed switch, that we'll swap? Was there evidence they would swap, or was it just evidence, well, we'll deal with it later? I mean, I'm trying to understand, what is there any evidence we will swap? And what is that evidence?
On the day of closing, Jeff Keeter, the attorney for the third party defendants, provided the email communications back and forth between himself and Jeff Porter, the plaintiff's attorneys, that unequivocally provided that the plaintiffs decided that they would simply stay with the deed that referenced slip A, but that after closing, they would swap. Now, the plaintiffs in their depositions did dispute whether they ever authorized their lawyer to say that, but they never disputed, because they can't dispute, that their lawyer said that. Their closing lawyer said, and when you look at the email communications, to which again are on document exhibit pages 213 and 214, Mr. Benson admits that, in fact, sure, we're willing to do that, but only if you agree with us to limit your use of your driveway easement. So, you know, again, I don't think that evidence is in dispute that this mistake was made. It was a draftsman's error. No dispute that the Prevosts were to receive slip A. The conveyance didn't do that. The Connor Act does not prevent a reformation action, given especially that the Bensons knew about that mistake. Because again, the Connor Act only applies to real property, and a boat slip does not real property make. The final issue I want to address before turning it over to Mr. Crouch is the issue regarding cost. It is clear that Judge Quinn intended, when he entered his summary judgment order, to retain jurisdiction for the entry of an order on cost. He did that. His order awarding cost sets forth detailed findings of fact and conclusions of law as to why this action was frivolous, why this action was not justiciable, even after, as the record shows, the plaintiffs knew that there was no evidence that they could present to support their allegations. They persisted in litigating this case. Significant efforts were made by the defendants and third-party defendant to resolve this case. They were rejected. So it's our belief that, again, as a matter of, again, and this is subject obviously to de novo review, the action never presented any justiciable issue, or they persisted in litigating the case past the point when they knew that their pleadings no longer contained a justiciable issue of fact, and it was therefore in Judge Quinn's discretion whether to award fees or not.
Mr. Shipman, Your Honor, if I may have just one moment, and just follow up on that. I'm looking at the order again, R150, paragraph 6D. There's a timing mechanism that the parties have to comply within 30 days. So even if we were to hold that, you know, the trial court was retaining jurisdiction, if the plaintiffs hadn't appealed within that 30 days, wouldn't they have been contempt of 6D, even if they were waiting on a cost order? So wasn't it becoming, you know, pressing to file before the 6D kicks in?
Your Honor, they could have been, not after the appeal was filed. The trial court would not have been able to hold them in contempt for failing to execute those documents. But if this court affirms, and they had not done that, but for an agreement on our part that pending this appeal they didn't have to, then sure, they might be held in contempt for their failure to do that in 30 days. That's a different issue as to whether or not the trial court retained jurisdiction to enter an order on cause.
Thank you, sir. Thank you,
Mr.
Chief.
Crouch, would you like a moment?
Yes, Your Honor. Thank you very much. Mr. Shipman and I thought we were going to work this out a little more. So I appreciate just a couple of minutes, Your Honor, and I'll, Ollie Crouch, I represent the third-party defendants. May it please the court. The appropriate place for me to begin my argument is a prayer for relief in the third-party defendant's answer, which I quote, that the plaintiffs and defendants be ordered to execute documents necessary to correct the ownership of boat slips A and C, and that the third-party defendants be awarded their attorney's fees and costs. We know from the decision in Westover Products that I've cited on page 8 of our brief that summary judgment may be granted to any party whether they move for it or not. We also know from the Messer versus Laurel Hill Associates on pages 8 and 9 of my brief that a court under certain circumstances may grant an untimely motion for summary judgment, in particular when the issue upon which the court rules is brought in a timely motion. In the instant case, in addition to the prayer for relief in the third-party defendant's answer, the defendant's motion for summary judgment raised the same issue. Whether the boat slips were personal property or pertinent to real property, the trial court was correct to order the plaintiffs to swap. And I use that word in quotes because that's exactly what Mr. Benson, through the closing lawyer, told Mr. Keeter they were going to do, to swap boat slip A with defendants and for the defendants to transfer slip C to plaintiffs. The trial court's order required the plaintiffs to do what they authorized their closing attorney to tell the grantor's attorney they would do. In doing so, the trial court also ordered the relief that the third parties had requested. The court's ruling on the boat slips and related documents reflects what the court thought about the plaintiff's conduct at closing. And I argue that the court decided that the plaintiffs could not win the race to the Register of Deeds when they had handicapped their closing attorney and the seller's attorney when there was an opportunity to correct the error, an error that they knew they were not entitled to take advantage of.
So did the closing attorney represent the Bensons, or do they represent? I mean, because there's like some bar opinions on who they represent. They can represent the bank, they can represent the seller because they prepare deeds sometimes. They represent a lot of people. I mean,
yes, Judge Dillon. The fact is that Mr. Porter represented the Bensons. In fact, Mr. Porter, and it is at least the copy of the trail of emails that I have is documentary exhibit 189 and 190. And Mr. Peter, who represented the sellers, WB, Island Drive WB, told Mr. Logan, who is a member of the Island Drive WB, he got a call from Porter. He now says, and this is after the Bensons and Mr. Porter recognized that there was a mistake because Mr. Porter notified Mr. Logan that we're going over the papers now and actually have a question. I think the boat slips may have gotten flipped or something. The deed to Bill and Monique, that's the Bensons, conveys boat slip A, but they are looking at the map and they say they're supposed to get boat slip C on the right. So later on in the series of emails on page documentary exhibit 190, just got a call from Porter. He now says that boat slip C has previously been conveyed to the Prevost. The Bensons want to keep the deed as it was, slip A, and then they will just swap with the Prevost after closing. They're going forward with boat slip A.
Thank you, Mr. Crouch. We can read that further on our own. Thank you, sir. I appreciate your argument. Thank you, sir.
Thank you, Your Honor.
Mr. Edmonds, rebuttal?
Thank you, Your Honor, and again, may it please the court, some points. I'm advised by Mr. Grady Richardson, who is the trial counsel in the case, that there's no encroachment, but more to the point, the metes and bounds of the easement weren't litigated, and I don't think the record would support a lot of findings one way or the other on that. So, you know, I hope the court won't get too into those particular weeds. Second, In his argument, Mr. Shipman, like the trial court, spent a lot of time talking about reasonable use of the easement. But under easement law, you begin by looking at whether or not the easement is ambiguous or not. If it's unambiguous, you look no further. And here we have a driveway easement. And this court has said in the Torres case that the sole and obvious purpose of a driveway easement is access to a platted road. So we go no further. We don't have to even look at reasonableness. We know what kind of easement we've got here. Third, Mr. Shipman argued that the Bensons were not bona fide purchasers for value. Well, if you look at the Bensons' deposition testimony, you will see that, in fact, they denied that they knew that there was any error or any mistake or any question about who got which boat slip. According to Mrs. Benson, they specifically asked, they brought it to their attention because they weren't sure what they were looking at. The closing attorneys checked and advised them, no, the change of title are clear. You are getting boat slip A.
But did the lawyer tell the sellers, did Mr. Benson, did the Benson's lawyer tell the sellers they're going to swap, they're going to take title to A, but they're going to swap with the Prevost? Did they make that representation?
They didn't. In their depositions, they deny it.
Mr. Evans, let me ask you a question real quick. On page 8 of your reply brief, and you touched on a little bit in your opening brief, but you refer to Miss Prevost's testimony as being incompetent as to prove the grantor's intent. Is this an issue of incompetency or lack of relevancy? Because if she's testifying as to what they're talking about, isn't she just talking about their then existing state of mind or their actions in conformity therewith, which would be admissible?
Well, Ms. Prevost wasn't around when the easement was created, so I don't think she's in any position to talk about what the creators of the easement were planning.
Well, that brings me to one follow-up. Is the important timing of when the easement was created the recording of the map or the inclusion of the language in the deed to the Prevost? So are we talking about earlier in 2015, or are we talking at the time of closing as to the intent of the grantors?
Well, I think that the grantors created the easement on the plats. So the easement's been in place, although as Mr. Shipman correctly pointed out, it was tweaked at one point.
But as the owner of both parcels, they could have gotten rid of it. They could have done anything. So really the interest that the Prevost received comes from the deed, not necessarily the plat, correct?
That's correct. I mean, the deed would show what they received, that they got boat slip A.
I'm sorry, I'm talking about with the driveway easement, in consideration of the driveway easement portion, and what the expectations were with that. If we found it to be ambiguous and we got down into what the grantor's intent was at the time of creating the instrument, are we talking about the map, or are we talking about the deed which really creates the easement? Because that deed could have given more rights, it could have given less rights, since they held both pieces of property. So I guess, could Miss Prevost's testimony be relevant to the grantor's intent at the time it includes the easement in the deed? Or is that completely irrelevant because we should be looking at the time of recording the map?
Well, again, I'm not a land use attorney, but I would think the creation of the plat, or the plat, showing the easement and defining it as a driveway easement would be what would be critical in defining in this case. My time is well up, I'm afraid. I will.
Well, we've all done very well with giving each other some good opportunity to sort out all the issues.
Thank you very much, Your Honor.
Thank you, everyone.
We appreciate
I'll
it.
take more time if you'll give it to me.
Thank you anyway.
Thank you, everyone.
Thank you, Your Honors.
Yeah.
Mr. Sewell, would you please adjourn court?
Thanks.
This session of the North Carolina Court of Appeals is now adjourned.
Thank you.
See you guys.